Your name?
Austin Carraway.
All right. Sir, you're here this morning in case 2021 MM457AW on a charge of battery domestic violence. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Okay, I'm sorry. All right, so we're going to set your bond in this case in an amount of $2,000, conditional your bond that you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement if you have a shared residence to retrieve any personal items that you have at that location. You may not possess any weapons or firearms. Any weapons and firearms you have need to be turned over to law enforcement within 24 hours of your release.
Okay.
Do you have any questions about your no contact order?
No, Your Honor.
Hear me? I can't hear you.
No, Your Honor.
All right. I'm going to appoint the public defender to represent you in this matter. You have a great day. Good morning, ma'am. Can you tell me your name?
Jeanette Lafountain.
Ma'am, you're here in case 2021 MM5176AO on charge of battery domestic violence. I did review the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in this matter in the amount of $500. It's going to come with pretrial release supervision. You to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You also may not possess any drugs or alcohol without a valid prescription. You subject to random drug and alcohol testing through pretrial release in this case. I'm going to appoint the public defender to represent you in this matter. You have a great day, ma'am. All right. Oh. Yep.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Good morning, Madam Interpreter. Can you see if you can make a connection with my lectern here at the BRC?
Yes.
Sí.
There is contact, Your Honor.
All right. Good morning, sir. Can you tell me your name?
Ramiro Roblero.
Ramiro Roblero.
Sir, you're here in case 2021 CF 8848AO on charges of battery domestic violence by strangulation and on account of battery domestic violence. I did review the charging affidavit in your case, and I did find probable cause for your arrest. I'm going to set your bond in count one in the amount of $2,000 and count two $500. Conditions of your bond will be that you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return if you have a shared residence with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this matter. Do you have any questions about your no contact order?
Sí. Pues si me dejan de ir a mi casa, pues sacar mis cosas y dejar a mis hijos.
Yes, if I would be allowed to go back home, take my things out, and leave my children there.
You need to go with law enforcement. So I gave you a one-time return with law enforcement to retrieve your personal items from the location. So that means tools, toothbrush, clothes, not the TV, not the sofa. No large items. You're not going to have time for that. Just get your personal items, make a go bag, and leave. You understand?
Sí.
Yes.
Have a great day.
Muy bien.
Good afternoon, sir. Can you tell me your name?
José Arturo Torres Rosado.
Jose Arturo Torres Rosado.
Mrs. Torres Rosado, you are here in case 2021 CF 8839AO on a charge of aggravated assault, domestic violence, and battery domestic violence. I reviewed your charging affidavit in your case, and I did find probable cause for your arrest. I'm going to set your bond in count one in amount of $2,000, count two $500. You'll be subject to pretrial release supervision. You to have no contact with the victim in this case. You are to maintain a separate residence from her. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to give you a one-time return to the residence with law enforcement to retrieve any personal items you may have at that location. 1 second. I'm going to appoint the public defender to represent you in this matter. Actually, hold on. 1 second. Take that back. Sir, it says you make $1,000 a week.
Sí.
All right. You're not
Yes.
going to, I'm sorry. You're not going to qualify for the services of the public defender in this case. So you're going to have to hire your own attorney or you're going to have to represent yourself. All right. Have a great day. Good morning, ma'am. Can you tell me your name?
Good morning. My name is Adriana Marquez. Adriana Marquez.
Ma'am, do you need the services of the Spanish interpreter?
No,
All right.
it's just I want to make sure that I understand everything correct.
Okay.
Just
Well,
like
if you're going to
many
use
words
this,
that I don't know.
if you're going to use the services of the Spanish interpreter, then you need to respond to me in Spanish so that we have a clear record. So we're going to try this again.
Okay.
Good morning, ma'am. Can you tell me your name?
Buenos días. Mi nombre es Adriana Marquez.
Good morning. My name is Adriana Marquez.
Ma'am, you are here in case 2021 MM5204AO on the charges of battery domestic violence. I did review the charging affidavit in your case. I did find probable cause for your arrest. I'm going to set your bond in this case in amount of $250. It's going to come with pretrial release supervision. You have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at a shared residence. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You also may not possess or consume any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing through pretrial release. I'm going to appoint the public defender to represent you in this matter. Do you have any questions about your no contact order, ma'am?
Sí.
Yes.
Not about the facts of your case, but about the no contact order, with the instructions that the court is going to instruct you. Like, you gotta stay 500 feet away.
No, está
All
bien.
this kind of no contact, no social media contact, no third party contact. So no contact. Do you have any questions about that?
Yo tengo una hija que vive conmigo.
I have a daughter. She lives with me.
You mean children?
Yo tengo una hija de 6 años que vive conmigo.
I have a 6-year-old daughter and she lives with me.
Okay.
I'm supposed to live with her from the... Estoy supuesta a irme de la casa con ella.
So I'm supposed to leave the house with her?
Let me make sure. Let me look at one second. If you share the victim in this case, If you live in the same house with her, then yes. So you guys want to find a new place to live with your daughter. At least while this case is pending.
Okay. Okay.
Okay.
All right. Have a great day, ma'am. Thank you, Madam Interpreter.
Thank you, Your Honor.
Good morning, sir. Can you tell me your name?
Tony B. Robinson Sr.
Mr. Robinson, you're here in case 2021 MO 850 AO on charge of open container. They did review the charging affidavit yesterday. Did find probable cause for your arrest. There was an offer to resolve your case via the withhold adjudication of guilt and court costs. You want to take that offer from the city today?
I didn't hear the latter part, sir.
You don't want to take the offer of a withhold adjudication of guilt, credit time served, and court costs.
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you'll give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down. Sir, you're here in case 2021 MO 850 AL on charge of open container. That is a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve your case with the court today?
No contest, sir.
Do you understand by entering a plea of no contest, you're going to waive all your rights outlined on the plea form that's in front of you?
Yes, sir.
Are you under influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
I did have an opportunity to review your charging affidavit. I did find a factual basis contained therein. I'll accept your plea of no contest. Find that your plea is freely and voluntarily entered. I want to withhold adjudication of guilt. Give you credit for 3 days in Orange County Jail with 3 days credit time served. The court costs in this case are $223. I give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing.
Yes, sir.
You have a great day, sir. Good morning, sir. Can you tell me your name?
Enrique Augusto Jr.
Mr. Augusto Jr., you're here in case 2021 CF 8605 AO on a warrant signed by a judge finding probable cause for the charges of attempted second-degree murder, battery, domestic violence by strangulation, aggravated assault with a deadly weapon, and battery. We're going to set your bond in count 1, amount of $50,000, count 2, an amount of $5,000. We're going to stay your other bonds amount of $2,500 on each count. Condition in the bond, you have no contact with the victims in this case. As you maintain or any other witnesses, you must maintain a separate residence from these victims. I give you a one-time return to any shared residence you have with law enforcement to retrieve any personal items you may have at the location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this matter. You have any questions about your no contact order?
No, sir.
Yeah, all right. All right, have a great day, sir. All right. Let me show you. I gave you only one, right? Okay. No, so make sure I didn't give you 2 files. All right. Good morning, sir. Can you tell me your name?
Good morning. Joe K. Faceless.
Sir, you're here in case 2021 CF 8853 AO on a charge of aggravated child abuse. I did review the charging affidavit in your case. I did find probable cause for your arrest. I'm going to set your bond in this case amount of $10,000. Condition your bond that you have no contact with the victim in this case. You need to maintain a separate residence from this victim. One second. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You'd have no unsupervised contact with any child under the age of 18 years old. I want to appoint the public defender to represent you in this matter. You have a great day, sir.
I got a quick question. She's supposed to go to school. And I'm
She's in protective custody with DCF, isn't she?
I don't even know what's going on at this point.
Based on the report I read, she's with the Department of Children and Family Services.
Okay, so as far as schooling, 'cause I'm supposed to enroll her, they gonna handle that, or?
There, you will have a dependency case, I'm quite sure, to follow along with this case that you have to address all those things with the debt judge with. All right, have a great day, sir. Good morning, ma'am. Can you tell me your name?
Zainab Otiki.
Ma'am, we're here in two matters. The first one is 2021 MM 322AA on charge of battery. You're also here in case 2021 CF 8854 AO on charge of escape, resisting officer with violence in 1, 2, 3, 4, 5 counts. Yeah, assault on a law enforcement officer in count 7 actually. And then aggravated assault on law enforcement in count 8, aggravated battery count 9, and then robbery count 10. Am I off?
Yes, Your Honor.
Let me look at the charging affidavit. Wait a second. Let me look at the charging. Okay, we got escape count 1, resisting officer with violence in 5 counts. Assault on law enforcement officer in another count, aggravated assault on law enforcement officer in another count, aggravated battery, and robbery, sudden snatching. All right, so state.
Yes, Your Honor.
Not sure, the escape charge kind of, what, did I miss something? Because
I believe
they struggled to get her in the car. Once they got her in the car,
I believe it was the crab walking aspects that happened multiple times, Your Honor.
yeah, I think that happened before they even arrested her, from what I understand. I mean, I'll go to more the resisting, at least the resisting without, and then once they got her in the car, or actually got the cuffs on her and hobbled her and got her in the car, you know, she's just doing what a lot of what we call normal activity for people that are resisting at that point. To that level, we required 5 law enforcement officers to get her in the car.
Oh, I believe she was under arrest before she was placed within the vehicle. I mean, she was in restraints and told that she was under arrest. And that's when she actively began to resist. They put her in handcuffs due to her combative resistance. They told her multiple times that she was under arrest, and she continued to try to back away and crab walk in an attempt to escape. They tried to restrain her, and she used her back leg and attempted to strike the officer in the face.
Yeah, I'm good with the resisting with. I'm fine with that. I'm just.
I believe she
I
was
guess,
under arrest as, I mean, she was not free to leave, and she was in cuffs before all the crab walking occurred. She does not have to be placed within a vehicle to be under arrest.
All right. I mean, I guess. Ms. George, what do you think? Because like for me, it's kind of borderline because she's handcuffed, but she didn't just run away, which is, I mean, I would clarify that as more of trying to escape, but.
Initially, when I read it, Your Honor, that was my thought. I read it. It did not appear she actually escaped. It just appeared she.
Well, escape is one of those findings like petty theft. So it's like you can escape or attempt to escape and still be guilty of the crime of escape in the state of Florida. So my question was she actually she didn't escape, obviously. So the question is whether she attempted to escape. You know, when is crab walking more of a resisting technique than escaping?
Your Honor, Reading it and reading the statute, I, at the very least, thought it may have been an attempted escape, just by reading the statute, but I would argue for a resisting, because she never got away. She was on the ground, she was kicking. She did crab walk, but she didn't get very far. She was still within range of the officer. So for probable cause purposes, Your Honor, I thought there was, she may have, you could argue that there was an attempted escape.
Briefly, Your
At
Honor,
least.
the statute only states escapes or attempts to escape from such confignment. State would just argue that cuffs are confinement, and I believe she made it all the way, she crab walked twice. The second time, she made it all the way to the door and was knocking her head on the door, arguably trying to get inside. So since the statute only states confinement or attempts to escape from such confinement, state would contend that cuffs are confinement. It doesn't have to be a facility or vehicle or other type of
All right.
device.
I'll go, I'll find PC for escape. I mean, more than attempted escapes, more of the language. Like I said, once again, most of these cases you see at least headlong flight, jumping out of the car, all those kind of things like that. But usually the normal fact pattern, but doesn't mean that the state's not going to pick up that charge. They will, it may or may not. All right, so I'll start with this felony cases we're talking about, 2021 CF 8854 AO. That's an escape charge, going to set your bond in the amount of $1,000. As to the first count of resisting officer with violence, going to set your bond amount of $2,000, be $150 for the remaining 4 counts. The simple assault, $100. Aggravated assault on a law enforcement officer, I'll set at $150. Count 5, aggravated battery, I'll set that bond an amount of $3,500. And the robbery statute, I'll set bond amount of $150. In your 2021, the same condition is going to be on both cases. 2021 MM 322 AA, going to set your bond in that case amount of $1,500. Condition on the bonds, you have no contact with the victims in these cases, no contact with any witnesses from these cases. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You must maintain a separate residence from the victims. I give you a one-time return to any shared residence with law enforcement to retrieve any personal items you have at that location. You are out on this case. You're on bond in case 2021 MM 195 AA. In that case, the court is going to revoke that bond. I'm going to set a new bond at $0 as to that matter.
Your Honor, I understand in this case, the new charges she picked up, they were violent in nature. I just ask that you consider revoking and increasing the bond amount. My client is, if you look, she is 19. I don't know what was going on that day. She has no criminal history other than that. And school is coming up. She's actually supposed to go to Huntsville and register for school this week. So I just ask that you consider that and the fact that she has no criminal history and consider revoking and doubling that bond.
Well, I probably may have, it was just a straight DUI, even though it was extremely high, like the DUI, but it's more of the resisting. Then there's just an elevation in her behavior. Now, I don't know what's going on with her. You may need to address whatever's happening that caused what I read in this report. So if it's treatment, if you need some new psychotropic medications, I don't know what's going on, but you need to address that so you don't keep seeing me. All right. So everything, don't say anything. Everything you say is recorded. I'm just giving you a little life advice because it's a little early to start off your adult life with these kind of charges. All right. right, have a good day, ma'am. Good morning, sir. Can you tell me your name?
Morning, your mask on.
Good morning. Irving Perez.
Mr. Perez, you're here in case 2021 CF 8855 AO on charge of criminal mischief, $1,000 or more, and battery dating violence. They reviewed the charging affidavit in your case. Did find probable cause for your arrest. Gonna stay your bond account one at the amount of $1,000, count two, $500. Condition of your bonds that you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at a shared residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I'm going to appoint a public defender to represent you. First, answer my question. Do you have any questions about the conditions of your no contact order?
We do not live together.
Okay, that's fine. I'm just giving, if you stayed at her house and you left some,
No.
I don't know.
No.
I'm giving you a way to go, pick up, you left some underwear, toothbrush, go bag, overnight bag at her house, you can go pick it up with law enforcement. If you don't need it, you don't have to exercise that. All right? You have a great day, sir. Sorry, well, Mr. Perez, no. He says he makes $600 a week. No, I'm going to appoint a public defender. Yeah, I'm going to appoint a public defender to represent you in this case. You have a great day, sir. Good morning, ma'am. Can you tell me your name?
Yes, Nicole Batterby.
Ma'am, you're here in case 2021 MM 5179 AO on a charge of battery domestic violence. I did review the charging affidavit in this case. I did find probable cause for your arrest. Good morning, sir. Can you tell me your name and spell your last name?
Yes, Your Honor. Michael Pearson, Pearson.
All right, can you raise your right hand this morning?
Yes,
All right,
sir.
you gotta keep your eyes on me on here. You solemnly swear or affirm the testimony you're gonna give in this matter is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Reach your hand down. Can you tell me how you know Miss Batterby?
We met through a mutual friend back in Dallas, and she moved out here with me after we dated for about 4 months. She made the leap of faith and moved out to Florida with me, and we've been together ever since February 10th, 2020.
All right. And do you want to have contact with her while this case is pending?
Yes. I also want to, with all due respect, Your Honor, apologize for wasting your time. She should not be in here right now. I should not be in here right now. I'll give you a little short story. We just moved here, and moving,
Right.
I'm prescribed an anxiety medicine, and the moving had me taking my full dosage of my medicine. And when I take my full dosage, I get a little angry and aggressive, and I get angry and aggressive verbally. And I said some stuff to her that like I deserved to get, like, she barely struck me. But it wasn't like I deserve. Like, what I'm trying to say is I deserved it.
That's it. All right. Has there been previous instances of domestic violence between you all in the past?
No, not at all.
All right. Did drugs or alcohol play a role in this incident?
No.
All right. Miss Davis, do you know what warrant she has out from Texas? What was the charge? Like, because it says,
Police.
oh, it says obstructing, like a resisting case? I couldn't tell if that was the charge or not. All right. All right, Ms. Batterby, in this case, I'm going to set your bond in the amount of $1,500, conditioning your bond that you have no hostile contact with the victim in this case.
Your Honor, state would just like to bring your attention to like the last two sentences of the affidavit. There's a prior open battery case against her from a few days ago, and there's been 7 calls in the past 3 days.
That was all me overreacting because of my medicine.
Stop.
Yes, sir.
Just stop it.
We're here because of me.
All right. That just stays right. All right, Ms. Batterby, still bonds $1,500, conditioning your bond, you don't have no contact with the victim in this case. You need to maintain a separate residence from him. You need to not possess any weapons or firearms. The weapons or firearms you have need to be returned with law enforcement within 24 hours of your release. You also give your one-time return with law enforcement to retrieve any personal items you have at that location. All right.
And I do plan on filing an injunction just so that.
Hold on. That's, you got a point of public defender to represent you. You can work on whatever you need to work on outside of this proceeding. And with Mr. Pearson, if you no longer want to be with him, that's just, life. All right.
Yep, that's her decision.
Yeah.
I'll respect it.
All right, but do you have any questions about your no contact order though? So right now it's a one-way street. All right, so you cannot have any contact with him.
Sir.
All right, so if he's trying to contact you, you got to do everything. I mean, like
I won't.
anything
If she
in
doesn't
your
want me to,
power to not have contact with him. You understand?
Sir.
'Cause otherwise, you'll be violating my orders, and that's not going to go very well for you. You understand that? All right, you have a great day. Good morning, sir. Can you tell me your name?
Good morning, Your Honor. Tariq Kalali.
Sir, you're here in case 2021 MM 456 AW on charge of battery domestic violence. I did review the charging affidavit in your case. I did find probable cause for your arrest. Good morning, ma'am. Can you tell me your name and spell your last name?
Good morning, Your Honor. My name is Shayna Shaw, last name S-H-A-W.
Okay. And can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right. Can you tell me how you know the defendant in this case?
I've known him for over 9 years. We have been friends ever since. And then just 5 years ago, we connected and got married and had our beautiful daughter and have been together ever since.
All right. And do you want to have contact with him while this case is pending?
Yes, Your Honor.
Has there been previous instances of domestic violence between you all in the past?
Unfortunately, yes, Your Honor.
And was this the last case from April of this year? Or is it April 2018?
I see 2018.
All right, because it says 418. I didn't know. Sorry, so from April 2018 was the last incident, or what was the most recent?
Oh, no. That's from a previous incident.
All right.
No, we had an incident in February between him and I, but that was already resolved and thrown out and over and done with.
Okay. It doesn't seem to be resolved if you're here with me. But
This was
all right. Did drugs and alcohol play a role in this incident?
not at all.
All right, sir, I'm going to set your bond in this matter. The amount of $1,000 is going to come with pretrial release supervision. In order that you have no contact with the victim in this case, you need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm also going to appoint a public defender to represent you in this matter. Now, not sure what's going on with you, sir, but if you'd not like to come visit me on a regular basis, which is starting to seem like this is becoming a regular basis occurrence, you come to see one of the judge's initial appearance because of domestic violence, you may want to enroll yourself in a batter's intervention course and figure out some tools that you can use to stop coming to see me. You understand that?
I do, but Your Honor,
I don't.
Okay.
This is not about excuses, about anything like that. If for your well-being, you may just want to get some tools to handle the situation better, so law enforcement isn't called. Just not by her, by somebody's hearing you arguing, seeing you arguing, may make your relationship better with your daughter, because you have a beautiful. That's your daughter, correct? She's beautiful. All right. This situation between you all is detrimental to her. Go Google it. Don't take me for word for it.
I agree with you.
Children that live through domestic violence, even at ages young as 6 months years old, understand and are affected by that. All right. So somebody needs to stop or get figured out between the both of you. All right. If you all want to stay together and make sure your daughter is not affected by this. all right? Yes,
May
ma'am.
I say something, Your Honor?
Yep.
He's the sole provider. I don't have an income.
Okay.
And he works remote from home. And I don't want this to affect his job. So, I mean, as far as his work is concerned and things like that, he's not allowed to even come and work from home.
What do? You on the internet? You need internet access to do your job, apparently? All right. So you can have internet access from Starbucks. I don't care where you're getting internet access from. I was just, since you have this beautiful daughter, you continue to pay the bills, so she makes sure that she's, appropriately taken care of while this case is being figured out, okay? So,
I absolutely will do that. The challenge for me is it's financially, I can't pay for 2 locations in Orlando.
yeah, you guys can figure it out for a little bit. You figure in front of Judge Wayne Shoemaker, and he's the judge for your case, and maybe you can find out a better living situation between the both of you. But right now, probably something needs to change first, most importantly, before anything else. Because who cares if, seriously, is the money that important? We talk about her.
I agree.
Is it really that important? About her well-being. So we should be focused on what her well-being is going to be in the future, not just what our present problems are right now. All right? Have a great day.
Okay, thank you.
All right. Good morning, sir. Can you tell me your name?
Arthur Johnson.
Mr. Johnson, you're here in case 2021 MM320AA on charge of battery domestic violence. Did review the charging affidavit in your case. Did find probable cause for your arrest. One second. Going to set your bond in the amount of $100. Going to come with pretrial release supervision. You're going to have no contact with your brother while this case is pending. You may not possess any weapons or firearms. Weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. All right, you're going to have to maintain a separate residence from him. We have a one-time return with law enforcement to retrieve any personal items you have at that location. We're going to appoint a public defender to represent you. All right, because you are 20 years old. This is cool, about 3 years ago, but you can't fight with your brother like that. All right, have a great day. Good morning, sir. Can you tell me your name?
Wayne Johnson.
Mr. Johnson, you're here in case 2021 MM5178 AO on charge of battery domestic violence. Did review the charging affidavit in your case. Did find probable cause for your arrest. Going to set your bond in this case in an amount of $1,000. It's going to come with pretrial release supervision that you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement if you need it to retrieve any personal items you have at a shared location. You need to you must not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this matter. Do you have any questions about your no contact order? All right. Ms. Davis, is this a child support case or something? Was you already seen on it?
I'm not too sure.
All right. I don't have any information about it. It just came up on your face sheet that you may have a child support issue. You want to talk to one of the child support hearing officers or the judge later today. Have a good day, sir. Good morning, sir. Can you tell me your name?
Sheldon Stevens.
Mr. Stevens, you're here in case 2021 MM321AA on charges of battery domestic violence. Did review the charging affidavit in your case. It did find probable cause for your arrest. going to set your bond in this matter amount of $250. It's going to come with pretrial release supervision. You to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement if you need it to retrieve any personal items you have at a shared residence. You may not possess any weapons or firearms. The weapons and firearms you have need to be turned over to law enforcement within 24 hours of your release. Do you have any questions about your no contact order?
No, sir.
All right, have a great day, sir. All right, good morning, sir. Can you tell me your name?
Morning, I'm Isaac Alberto.
Mr. Alberto, you're here in the Seminole County case 2020 CF 1715. Judge for a violation of probation warrant. The judge in that case set your bond amount of $5,000. Your bond is going to remain in that amount of $5,000. If you cannot afford to post that bond, you'll be sent to Seminole County as soon as we can. You have a great day, sir.
I have a question. My mom, I spoke to her 2 hours ago. She said she already paid the bond.
Then you should be able to bond out. That may just not have happened before you got to see me.
All right, thank you, sir.
Have a great day. Good morning, sir. Can you tell me your name?
Alfonso Butler, sir.
Mr. Butler, you're here in case 2020 CT 1308 out of Columbia County. The judge in Columbia County set your bond on this warrant in the amount of $2,000. Your bond is going to remain as set in that amount. We're going to appoint a public defender to represent you. If you can't bond out, we'll get you on to Columbia County as soon as we can. You have a great day.
Yes, sir. I can bond out from here.
Yes, sir. You should be able to. Yes. Good morning, ma'am. Can you tell me your name?
My name is Jessica Gutierrez.
Ms. Gutierrez, you're here in 2018 CF 4526, a case out of Broward County for a failure to appear. The judge in Broward County set your bond at no bond. Your bond's going to remain as set in that amount. We want to appoint the public defender to represent you while you're here in my custody, and we'll get you on to Broward County as soon as we can. You have a great day, ma'am.
How long do they have to come get me from Broward?
I don't know.
All right.
Good morning, sir. Can you tell me your name? Mr. Holt, you're here in a Seminole County case, 2019 CF 3348 on a VOP warrant. The judge signed that warrant, set your bond at no bond. Your bond's going to remain at no bond. I want to appoint a public defender to represent you until we get you over to Seminole County. And we will hopefully probably get you there sometime later this week. Have a great day.
How long do they have before they come get me to take me to Seminole County?
I don't know. Good morning, sir. Can you tell me your name?
Alec Cost.
Mr. Cost, you're here in case 2020 CF 1512, as well as 2020 CF 1513. Both cases out of Seminole County for violations of probation. The judge in Seminole County set your bond at no bond. Your bond's going to remain as set in that amount. We're going to appoint a public defender to represent you to get you over to Seminole County, which may not happen until you deal with your out on bond cases, 2021 CF 8143 and 2021 CF 8175, which I'm not going to take any action on at this time. You have a great day, sir. All right, going to appoint a public defender to represent Mr. Faizon in his several matters. First one being 2019 CF 10679. Next one being 2019 CF 10680. 2020 CF 7743. 2021 CT 5311. 2021 CT 5312. 2021 CT 5314. I'm going to appoint the public defender to represent him in all those cases.
I'll waive the appearance, Your Honor.
All right. As to his violation of community control cases in 2021 CF 10679, 2019 CF 1079, 2019 CF 10680, and 2020 CF 7743 AO. There's already warrant signed. setting his bond at no bond for a violation of community control. As to his new cases, he was arrested on 2021 CT 5311. Going to set his bond, find probable cause for 2021 CT 5311, 2000 CT 5312, and 2021 CT 5314. Did find probable cause for his arrest as to all those charges. Going to set his bond amount of $1,000 in each one of those cases. Condition of his bonds that he's not allowed to possess or consume any drugs, alcohol without a valid prescription. He is to be randomly drug tested. He's also not to operate a motor vehicle without a valid driver's license, and not to possess any other person's identification except his own. However, he's
I'm so sorry. You want him RUA in all traffic cases?
yes. And he's out on bond in case 2021 CF 5835. And in that case, the court's going to revoke that bond, set a new bond at $0 as to that matter. Going to appoint a public defender to all cases that does he not already have representation? All right. Good morning, sir. Can you tell me your name?
Good morning, sir. And my name is Mandel Mclemore.
Mr. Mclemore, you're here in case 2019 CF 8850 AO on a violation of probation. The judge in this case set your bond at no bond. Your bonds remain as set in that amount. We're going to appoint the public defender to represent you in this matter. You have a great day, sir.
Sir.
Good morning, sir. Can you tell me your name?
Jonathan Shivers.
Mr. Shivers, you are here in case 2021 MM 5205 AO on charge of resisting officer without violence. They reviewed the charging affidavit in that case. Did find probable cause for your arrest. Going to stay your bond amount of $500 as to that case. You also arrested for on-view violation in case 2020 CF 12979 on a violation of probation. You're going to stay your bond amount of $0 as to that matter. You're out on bond in case 2020 CF 12976 AO. Court's going to revoke that bond, set a new bond at $0 as to that matter. Since I just set your bond at no bond, I am going to appoint the public defender to represent you in all of your cases. You have a great day, sir. Good morning, sir. Can you tell me your name?
Charles Washington.
Mr. Washington, you're here in case 2021. Sorry. Oh, I apologize. Sorry. Sorry, sir. Sir, you're here for violation of probation and warrant in case 2020 CF 9950 AO. As that warrant, the judge set your bond in amount of $2,500. Your bond's going to remain as set in that amount. I'm going to appoint the public defender to represent you in that matter. You have a great day, sir. All right, and let's go back to.
Okay. All right.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Good morning. If you could please connect to the headset. I don't know if he can hear you.
I'll try again.
Your name's gonna be called here soon.
Sí, lo escucho.
There is contact, Your Honor.
All right, sir, please tell me your name.
Rafael Borromeo Raimundo. Borromeo Raimundo.
Rafael Borromeo Raimundo.
21 CF 8856. You're here charged with resisting an officer with violence. I'm going to appoint an attorney to represent you in this case. There is probable cause. Your bond is $1,000. You can't possess a weapon of any kind, firearm, or ammunition. You can't possess or consume any controlled substance without a valid prescription. Good luck, sir. Sir, please tell me your name.
Sabas Orlando Solís Rodríguez.
Orlando Solis Rodriguez.
21 CF 8776. A warrant was issued for your arrest, charging you with attempted second-degree murder with a firearm, aggravated battery with a firearm, aggravated assault with a firearm, and improper exhibition of a firearm. Another judge has already found probable cause in this case, and I'll appoint an attorney to represent you. Ms. May, does the state wish to be heard?
Yes, Your Honor, as to count one, so it's asking that you hold him no bond pending an Arthur hearing.
I will do that at this time.
First charge order, do you see attempted second-degree murder?
It's attempted second-degree murder with a firearm.
Okay.
I think it's the firearm.
Yes.
On count 2, your bond will be $15,000. On count 3, $5,000. On count 4, $1,000. Even while in custody, you can't have any contact with a victim or any witness in this case. Do you understand?
Okay.
Okay.
You can't possess a weapon of any kind, firearm, or ammunition. You can't return to the scene for any reason. You can't be within 1,000 feet of the victim's residence or place of employment. Do you understand that?
Sí.
Yes.
All right, good luck. Is that it for Spanish interpreter cases? That's all we have for the interpreter this morning. Thank you.
Thank you, Your Honor.
Please tell me your name.
Ario Zohor.
All right. 21 CF 8861. Counsel, would you put your appearance on record?
Good morning, Your Honor. Ginger Miranda.
Good
Mr. Zohar.
All right, sir, you're here charged with 2 counts of lewd or lascivious battery, 2 counts of lewd or lascivious conduct by a person greater than 17, 2 counts of lewd or lascivious behavior, 2 counts of attempted lewd or lascivious molestation, 2 counts of contributing to the delinquency of a minor, 4 counts of lewd or lascivious battery, 2 counts of interfering with the custody of a minor incompetent person, 2 counts of obscene communication, and 2 counts of unlawful use of a two-way communications device. Counsel, have you already entered a notice of appearance?
I just picked it up, Judge, and I just came right over. I don't know if it's actually been e-filed just yet.
Okay. All right, but you intend to file it this morning?
Yes, Your Honor.
All right, did you wish to be heard on probable cause?
No, Judge, we're just asking for a bond to be set in this case. I have spoken to the state about it. We agree that a bond should be set in this case. Judge?
Yes, Your Honor. He is entitled to bond on all and under PBL or life offenses. So he is entitled to bond. So state asks that you stay the ones that are currently set and set bonds the ones that are currently set at no bond.
All right, I do think there's probable cause. I reviewed the affidavit prior to court.
Yes, Your Honor, he is a student at UCF. He's from Davie, Florida. His parents are here. They traveled here from Davie. They're in the box, here to support their son.
All right, did you want to present any testimony?
Yes, Your Honor.
Go ahead.
Thank you, Judge. Judge, I don't know if they have a microphone in there where
They
they
do.
could just, okay, great.
Yes.
Could you please tell the judge your name?
My name.
First, they have to be sworn in.
I'm sorry.
Sorry.
Raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Monica Suarez.
Well, one at a time. So let's start with her. I need her to spell her last name.
Suarez.
All right, go ahead, counsel.
Ms. Suarez, what is your relationship to Ariel Zohar?
I'm his mother
Okay, and where do you live?
in Davie, Florida.
And how long have you lived there?
We lived there for the past 20 years.
Okay, and do you have a home there?
Yes.
Okay, and do you also have a business there?
Yes.
Okay, and how long have you had that business there for?
We had the businesses for about 20 years already.
Okay, do you have other children?
Yes. two
Okay, and
daughters.
how old are they?
16 and 11.
Okay, and do they live in the home with you?
Yes.
If the judge were to set a reasonable bond this morning, would Ariel be able to come home with you?
Of course.
And you would welcome him into the home?
Of course.
And you have retained the services of an attorney for him, isn't that right?
That's correct.
Why I'm here this morning, okay? And would you be able to provide him transportation to attend any and all court hearings?
Of course.
That's all I have, Judge.
Any cross by the state?
No, Your Honor.
All right, thank you. Did you want to question the other witness?
Please tell us your name.
Eitan Zohar.
Okay, and what is your relationship to Ariel Zohar?
I'm the father.
Okay,
You put your hand down.
and do you agree with everything that your wife just said?
Yes.
Okay, thank you.
I want to make sure I understood. There are two minor children in the home.
Yes, Your Honor, his siblings.
All right. And remind me, I don't recall if you asked. Did you ask for a specific bond?
Your Honor, I would be asking for $25,000.
What says the state?
Your Honor, state would object to that amount, given the nature of the charges, the amount of charges, and given the victim's age. I believe she was actually 12 years old.
Yeah.
And given the repeated contact.
Give me 1 second.
And I believe all the charges that are currently set at no bond are all F2s. So the state would just contend that $25,000 is not reasonable, given that he's facing 2, 4, 5, 6, 7, 8, 9, 10, 11, 12, at least 12 F2s that are currently set at no bond.
All right, thank you. On counts 1 to 11, 12, 13, and 14, it's all the lewd and lascivious battery charges. Your bond is $5,000 on 3, 4, 5, 6, 7, and 8. On each of those counts, your bond will be $2,000. On 9 and 10, I'll stay it at 500, and I'll stay all of the rest. So it's 15, 16, 17, 18 are $2,500, and 19 and 20 are $1,000 each. With special conditions, you can't have any contact with the victim. Do you understand what no contact means? You also can't have contact with the victim's family members.
Yes, ma'am.
In a case like this, I would typically order no contact with any minor child under the age of 18. Does the state object to him being allowed to have contact with his siblings?
State would ask for that condition, but with an exception for the siblings. I don't know if he's still staying in school or if he would be returning
No,
to
Your
the
Honor,
home.
he'd have to return home. He's been asked to leave the school.
They testified they were going to bring him home, but there's 2 minor children in the home.
Yes,
Right.
Your Honor. Given that he's 18 years old, and his parents are willing to welcome him back, state has no objection to contact with his siblings, but with no contact with any other minor children.
All right, that is what I'll order then. So you can't have any contact with any minor child under the age of 18 except your siblings. Do you understand that?
Yes, ma'am.
You can't access Tinder or any other social media dating site at this time. Do you understand?
Yes, ma'am.
All right, are there any other conditions the state would request?
No, Your Honor.
Thank you for coming. Thank you, counselor. And sir, you should thank your attorney. She did a good job for you this morning.
Thank you so much, ma'am.
Good luck. Thank you.
Thank you, Judge. That's all I have before you this morning. May I be excused?
Yes, have a nice day. Thank you. I don't think this is her.
Morning.
Good morning, counselor.
Good morning.
Sorry, I think I have the wrong case. Do you want to call your case and put your appearance on record?
Yes, I'm here for Princess Vigilance, case 22.
21 CF 8324?
Yes, Alicia Adamson for the record. I don't think the NOA has been filed yet. I do intend to file when I just got the case.
All right, and ma'am, that is your name, right?
Yes, ma'am.
All right, you're here because a warrant was issued for your arrest, charging you with burglary of a dwelling with a battery, false imprisonment, aggravated assault with a firearm, and simple battery. I've already found probable cause in this case.
And my approach with I just have a little bit of mitigation. I've already provided the state with a copy. My approach.
Yes. Hold on, I'm gonna move this stack. It's in my way. Yeah, thank you.
Your Honor, I will be asking for the court to set a bond. There is no bond set on count one for obvious reasons. The state is objecting, and I do have 2 witnesses I'd like to call in for argument purposes.
All right, so let's start with the witnesses. Ms. May, I assume you have argument?
Yes, Your Honor.
All right, well, let's start with the witnesses and then we'll get to argument.
Raise your right hand.
Whoever's testifying has to raise their right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Hold on, let's go one at a time. Ms. Adamson, you just go ahead and call whichever one.
Yes, Patricia Daniel Porter, you can go first. Okay, please state your name and spell your last name for the record.
Patricia Danley Porter, last name Daniley, hyphenated Porter.
And how do you know Miss Vigilance?
I know Princess because she's my track athlete. I've been her coach now for a little over 10 years.
Okay, and is she still in school? What's her status?
So she just graduated from high school and was offered and received a full track and field scholarship to South Carolina State, and she's supposed to be attending on August 12th.
Okay. So she has a full scholarship to South Carolina State University and is supposed to report in 2 weeks?
Yes.
Okay. And you've been coaching her for a little over 10 years?
Yes, ma'am.
And in that, in you coaching her, have you ever known her to have a violent history?
No, ma'am.
Has she ever given you any problems as an athlete?
Nothing abnormal, except for just being like my own child.
What do you mean by that?
So, you have to remind them of make it to practice on time, making sure that you bring your practice clothes, that sort of thing.
Okay. But because of her success in her track and field career, she's been offered a full scholarship?
Absolutely, yes, ma'am.
Okay. And Sierra Jones is the victim in the case that we're here for today. Are you aware of the relationship between Sierra Jones and Miss Vigilance?
Yes, I am.
Okay, what is their relationship?
That is Princess's ex-girlfriend.
Okay, and have you ever had any encounters with Sierra Jones?
Yes, and a few other young ladies at a track meet.
And tell me about that.
So we were our first track meet of the season this past year. Princess she missed a race, and when I found her, she had been underneath the stadium hiding because a group of girls had come to fight her at a track meet. And upon me finding that information out, I was on the phone with my mother. I walked out to the parking lot because it was at the end of the track meet. And she had given me the description of the vehicle. And I was on the FaceTime with my mom and said, I'm out in the parking lot because Princess is scared to leave. And I want to make sure that these girls don't try to attack her on the bus. And when I said that, the girls literally were already out of the car in the parking lot and said, yes, we are here to fight Princess. Where is she? I told them there will be no fight because first and foremost, we're on, school campus, and that they needed to leave. And so I had to have my parents follow the bus to the high school where we were going to be dropping off and having the parents pick up the kids.
And was Sierra Jones one of the people that said that she was going to fight Princess?
Yes, ma'am.
Do you have any other, have you ever had any other encounters with Sierra Jones?
No, ma'am.
That's all I have.
Thank you.
Any cross by the state?
No, Your Honor.
All right.
Next witness I have is Tamia Harris.
We already swore all three of you in. I just wanted to take your testimony one at a time.
Ms. Harris, would you please state your name and then spell your last name for the record, please?
My name is Tamia Harris, Harris.
And what's your relationship to Miss Vigilance?
I'm the mother of Princess Vigilance.
Okay. And it's my understanding that you're currently undergoing chemotherapy?
Yes, I am for
Why?
stage 3 triple negative breast cancer.
Excuse me?
Stage 3 triple negative breast cancer.
Okay.
I'm on chemo, yes.
And Miss Vigilance is your youngest child?
Yes, she is.
Okay, and it's my understanding that she's supposed to be starting college soon?
Yes, ma'am. August 12th, she's supposed to report to South Carolina State on a track and field scholarship, full ride.
Okay, and who is her coach at that school?
Her college coach is Gerard Wims, W-I-M-S.
And have you talked to Gerard Wims since her arrest?
Your Honor, objection. It's hearsay. He's not testifying here today.
So, have you spoken with him? Yes, isn't hearsay, but you think that the next question will elicit hearsay?
Yes, Your Honor.
I'm going to overrule it as to that question. Let's see what the next question is.
Is the school aware of these charges pending against Miss Vigilance?
Yes, they are.
And are they still willing to accept her to school in 2 weeks?
Yes, they are.
Okay, and the coach also spoke to Miss Vigilance since she's been in jail, is that correct?
Yes, he has.
And that was on a jail call?
Yes.
Okay, and was supportive and
Your Honor, again,
welcome.
Yes.
Objection, it's hearsay. She was not on the jail call. That would have been between Miss Vigilance and the coach.
Okay, I'll move on, Judge.
Is hearsay admissible in an initial appearance? I'm going to sustain. It sounds like hearsay, Counselor.
Understandable. With in regards to Miss her going to school, does it appear to be that she would be able to come back and forth for her court appearances and still attend college?
Yes, she will.
And you feel confident with that?
Yes.
Okay. And you would help facilitate to make sure that if and when she has court, she attends properly?
Yes, ma'am, I will.
And you've retained an attorney to make sure that happens as well?
Yes, ma'am, I have.
And would you also help to ensure the importance of a no contact order between Princess and Sierra Jones?
Yes, I will.
Do you understand that if she were to be released and there was a no contact order, if Princess contacts Sierra Jones, that she would be back in jail?
Yes, ma'am, I understand.
Okay, and will you do everything in your power to make sure that Ms. Vigilance understands that?
Yes, ma'am, I will.
And if she were to have a bond set by the court, would you be able to bond her out?
Yes, ma'am.
Okay, is there an amount of money that you have on hand that you'd be able to afford to bond her out in an effort to get her off to college and away from Ms. Jones and Orange County?
$3,000.
Okay. That's all I have, Judge.
State?
No cross, Your Honor.
That's all I have. I'm not sure.
I have one question for you, ma'am. You live here in Orlando?
Yes, ma'am, I do.
Okay, sorry, I have two questions, actually. You said that you're being treated for cancer.
Yes, ma'am.
I'm sorry, and I hope the best for you. Are you being treated here in Orlando?
Yes, ma'am, I am.
All right, thank you.
That's all I have, Judge.
All right,
And you want me to just go into
go ahead with argument. Yep.
I'd also like to note for the record that Sierra Jones, the victim in this case, does have a closed felony case, 2020 CF 6953AO. It is a battery with strangulation felony case where Miss Vigilance was the victim in that case, and it was later no info based on my client declined to prosecute on that case. They are exes, and they have a very dramatic relationship. I think it's in everyone's best interest that they don't contact each other. Neither of them want to contact each other. And my client has no criminal history. I understand that you found probable cause. Even if we stipulate to proof evident presumption, great, Your Honor still has the discretion to grant a bond if she's not a danger. I would argue that she's not. She has absolutely no criminal history. She has a full ride scholarship. I provided documents for mitigation showing her class schedule, her acceptance documents, her national letters of intent, the agreement that she signed to start school, celebratory photos. She's been very successful in track and field, and the last exhibit is actually the various offer letters that she's had because of her commitment to track and field and being a student athlete. She recently graduated from high school, and I think that she's not going to be here. And so if the court were to grant a bond, she'd immediately bond out. And she's already spoken to her coach. Her coach is aware of these charges. They are still welcoming her to the school. They had a very encouraging conversation yesterday, and where he's like, just get here, stay away from the drama. When you have court, we'll make sure you get to court. And so I think that's just the best resolution for everyone. It makes sure that she's not in the same city, county, state as the victim in this case. The victim in this case has been an aggressor towards my client. While she's asserting her innocence, again, it's obvious that there was probable cause found, but I would ask that taking all of those things in consideration, that Your Honor grant a bond and a very strict no contact order to make sure that there is no contact so that she can go off to college and never speak to Sierra Jones again.
Thank you. State?
First, I know counsel made comment as to 20 CF 6953, the case against Ms. Jones, that she says was no bail due to the victim declining to prosecute. According to the notes in that case, it was actually no bail due to mutual combat. Therefore, the ASA did not go forward due to Ms. Vigilance also being a mutual combat in that case. As to the mitigation that was presented to the court, state just makes the argument that while persuasive that she does potentially have a bright career in front of her, the allegations in the affidavit they depict a malicious and pretty calculated attack on Ms. Jones. In the affidavit, there are multiple witnesses, all which corroborate the victim's account. I believe there was the witness Catchings, the witness Ms. Jones gave her an account. There was a witness, Ms. Cooper. I know you already found PC. However, there's also the victim testified to the officer that she was hit approximately 20 times and saw the defendant point a gun at her. That is corroborated from witness Cooper's account that she saw Miss Vigilance in the parking lot pointing a dark object at the victim in this case. So that account from the victim is corroborated by another witness. There was also video evidence of the attack, as well as the several injuries that the victim sustained. The state is contending that for her to be held no bond. It is a punishable by life offense. It's very serious. It was calculated. She took, I believe, approximately 5-ish people. I don't believe there was ever an exact count within the affidavit. To the residents, one was recording, another was helping attack the victim, and there was coaxing of the other women that were involved for them to all attack the victim. Photo lineups were also conducted, and everyone identified Miss Vigilance as being a part of this. Miss Jones the state did talk to Miss Jones. She is scared. She is looking into Harbor House because she is scared to go home due to the defendant knowing where she lives. And the only other argument state makes is, I understand that her mother testified to being able to pay $3,000. If Your Honor is inclined to set bond, state would ask for a much, much higher bond, given the nature of the offense and the seriousness of the offense. And in regard to the other testimony provided by Ms. Porter regarding the other events that she remembers from Ms. Vigilance telling her regarding hiding under the bleachers, the victim is not before the court today, and the victim is not here to testify as to what happened or give her side of that account. And again, that was testimony technically from the defendant saying what was happening. The victim was in her residence. Ms. Vigilance sought her out, went to her house, broke in with other individuals, was seen with a firearm, and ultimately assaulted and beat her with other friends. So I understand that they have a tumultuous relationship, which it seems to be done at this point. However, the victim was in her house and she was personally sought out in her house, which is under the law your castle, and it does have special protection. Given that this is a PBL, she is asking that you hold her no bond, given that this was very calculated, very malicious, and ask that you hold her no bond.
All right, anything else, Ms. Adamson?
The breaking in part is, I'm just trying to.
Wait, hold on, I can't hear you, sorry.
I know, I'm just trying to skim the arrest affidavit real quick before I.
They knocked, no one answered, and they entered an unlocked door. Your client first, and began hitting the victim, who then her other friends jumped in and helped, while recording and coaxing each other.
And I guess the Harbor House, seeking Harbor House, this was just recently, or she's been since this incident?
I believe that's recently.
Okay.
Because she's scared to go home due to your client.
Okay, my argument just remains the same based on her lack of history, and my client has a very different rendition of what happened that day, but I would just ask that based on her lack of history and her immediate relocation, that you would set a bond, keeping her in jail, literally taking away this once-in-a-lifetime opportunity, which I understand is a situation that, based on everyone making decisions, is why she's here. But this is, I just think the community is in a better place if she's off to college. So I would just ask that she be. It depends what you want to say. Sorry, she wants to say something, but I'm nervous. That's all.
You understand that anything you say is being recorded and can be used against you later? Yes, ma'am. All right, did you want to say something, or after talking to your attorney, did you change your mind?
I changed my mind.
All right.
Thank you, Judge.
All right, I thank you both, and thank you for coming. I appreciate all of your testimony and the argument from both attorneys. I reviewed the affidavit, and actually, I had previously signed this warrant, so it's one that I was familiar with because I signed it a few weeks ago when I was the e-duty judge. I also reviewed the exhibit list while I was listening to the testimony and the argument. Ms. Adamson, you are correct. Even though I found probable cause, and if I find proof evident presumption, great, which I do at this time, the court does still have the discretion to set a bond. In most cases, I'm not inclined to do that. However, in this case, I'm going to. But, Ms. Vigilance, I want to make sure that you understand what's happening here. This crime, and I'm not asking you to say anything, just so you know. This crime that you've been charged with is a first-degree felony punishable by life in prison. It's a very serious crime. And it looks to me like you have a support system that most girls in your position who end up here in front of me don't have. I don't know if what I'm saying to you will mean anything at all, but my hope is that it does. It looks like you have a really great opportunity in front of you, and whatever this situation was, you could end up throwing it all away. So I would just ask that you please listen to your attorney, listen to these women who came to support you. You have a coach who took time out of her life to come here to testify on your behalf. I feel like that's pretty unusual. I don't know that many girls your age would have that. So I'm just asking you to please listen to the adults in your life. And this is a tough lesson for you because your mom just told me that she's going to do everything she can to keep you away from this victim, to keep you in school, but she can't. You're 18 now. You're an adult. So now these are your choices, and this is the lesson that all adults have to learn, right? Now you're responsible for the consequences with your actions, and it's not your mother. So,
Your Honor, briefly, just one last point is we have no testimony today from anyone from the actual school stating that she is still allowed to be there. I understand that that is probably weighing heavily on your decision. However, I would just like to point out to the court that we do not have any representative from the school stating that she is still allowed to go there, and this scholarship opportunity is still available to her. So we just want to bring that to the court's attention, given we don't have that. And I know that's likely a big part of your decision here today.
it is, but honestly, the school cuts both ways for me because one of the things that the judge has to consider when deciding bond is the reasonable likelihood that you'll come back for court. And the fact that you are telling me you're going to be in another state, even if it's for a good reason for school, it means there's a chance you might not come back for court. So for me, it was a balancing test. I think it's definitely in your best interest to be in school and to not be here. Also, when I reviewed the affidavit, not only are there several witnesses that corroborate the victim's story, but there's a video. And in the affidavit, it says that in the video, Jones was thrown to the floor. After getting back on her feet, she was thrown on the couch and held down by Vigilance. Vigilance is seen punching Sierra Jones when the video ends. So there's video evidence of your client engaged in this attack that corroborates all of the witness's testimony that corroborates the victim. So I think there's proof evident presumption great here, but you have no criminal history, and so I will set bond. It will not be the amount that you're asking for, counselor, but I will set a bond.
Thank you, Judge.
All right, at this time, your bond on count 1 is $50,000. Your bond on count 2, I will reduce to $5,000, count 3 will be $5,000, and count 4 will be $100. You understand that while released, and even while in custody, you can have no contact with this victim.
Yes, Your Honor.
You understand what no contact means?
Yes, ma'am.
You can't contact her on social media, you can't speak to her, you can't send a text message, you can't send a message through friends or family. This is no contact at all. You understand that?
Yes.
You're not allowed to possess a weapon, firearm, or ammunition. You can't have any contact with any co-defendant or witness in this case. You understand?
Yes.
You can't be within 1,000 feet of the victim's residence, her school, or her place of employment. They don't work or go to school together now, right?
No, Judge.
So that shouldn't be a problem.
Not a problem.
Are there any other conditions the state would request?
No, Your Honor.
Like I said, ma'am, you have a lot of opportunity. I wish you the best. And good luck. I wish you all the best as well.
Thank you, Your Honor.
Thank you, Counselor. Ms. Adamson? I'm going to put it in the court file, but who has that before first appearance?
Yeah, that was literally like her village.
That's amazing. Could you approach for one moment? Okay, what? I'm ready. That was not about the case, Ms. May. Please tell me your name.
Melanie Bell.
21 MM 5195. You're here charged with petty theft. There is probable cause. I'll appoint an attorney to represent you. Your bond is $250.
I'm sorry, Your Honor. You went really fast.
Sorry, it's an enhanceable offense, so that's why I was thinking.
I was given an offer from the state.
She doesn't have any prior, she has, I believe, one prior, Your Honor. So we can't enhance to a 2 prior, and it wasn't over $100.
No, I just mean it isn't, it doesn't mean this one is
Yes, Your
enhanceable,
Honor.
but the next one is, so.
Oh, okay.
That's why I was assuming there wouldn't be a plea. I'm sorry.
I did speak to Ms. Bell. I did discuss the enhancableness of this offense, and she understands all of her rights that she will be giving up and the fact that it is, in fact, enhanceable. And she would like to accept the state's offer here today.
All right, raise your right hand.
I do.
All right, you heard what Ms. George just said. Is that what you want to do?
Yes.
And you understand all the rights you're giving up if you enter a plea?
Yes.
You understand what enhanceable means, that petty theft, after so many, it becomes a felony.
Yes, ma'am.
So it doesn't matter if the next one is a pack of bubble gum, it can still be a felony. You understand?
Which would be a
All right.
great reason not to do it again.
I'm sorry?
Which would be a reason to not do it again.
Yes, ma'am, it would be. I like the way you think. All right, you understand if you're on probation anywhere, this plea can violate that.
Yes.
And if you're not a U.S. citizen, you can be deported.
Yes.
All right, at this time, how do you wish to plead to petty theft?
No contact.
I'll accept your plea. I find it's freely and voluntarily made. What was the, was it
An adjudication credit.
and I'll adjudicate you guilty. I'll give you credit for the 2 days that you've been in custody. I have to order that you pay court costs. It's around $300. How long do you need to pay that?
Can you give me about, can I be on a payment plan for a good 3 months?
Yes, I can give you a year. I just want to make
Oh, yeah.
sure.
Yeah, that'd be good. I could give me a year, I'll pay it.
All right, I'll give you a year to pay it. You cannot return to Walmart at 5991 South Goldenrod. Do you understand?
That is understandable, yes, ma'am.
All right, have a nice day. Good luck. You have 30 days to appeal in writing.
Okay. Thank you.
Yes. Her last name was Bell, right? Miss Bell, I found you delightful this morning, but for your sake, I hope I don't see you again. Good luck.
Yeah, Mr. Miller here.
All right.
This is Mr. Miller.
21 MM 5201. Sir, you're here charged with trespass on property after warning. There is probable cause. Was there an offer?
Yes, Your Honor, the offer conveyed was an adjudication, credit time served, and no return to the Wawa.
All right.
And, Your Honor, I had a chance to speak to Mr. Miller. We went over all the rights he would be giving up. He understands those rights and would like to accept the state's offer here today.
Mr. Miller, can you raise your right hand, please? Raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right. You heard the state's offer. Do you want to accept that today?
Yes, I will.
You can put your hand down. You had a chance to discuss with Ms. George all the rights you'll be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, I do.
Do you have any questions for me about them? You understand if you're on probation anywhere, this plea can violate that? And if you're not a U.S. citizen, you can be deported. All right, sir, at this time, how do you wish to plead to trespass on property after warning?
No contest.
No comment.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days that you've been in custody. I have to order that you not return. And sir, I have to order that you pay court costs. Do you have a job?
No.
He does not. It appears he is transient, Your Honor, so I would just ask that you,
I'll reduce it to a lien.
yes, Your Honor.
All right, good luck,
Words
sir.
out, I'm sorry.
I got it. Good luck, sir. You have 30 days to appeal in writing. Please tell me your name.
Earl Taylor.
21 MM 5202. You're here charged with battery, retail petty theft, resisting a merchant, resisting an officer without violence, and criminal mischief. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $500 on count 1, $100 on 2, 3, 4, and 5. You're not allowed to have contact with any victim or witness in this case. You can't return to the CVS at 5300 South John Young Parkway. Do you understand that? I can't hear you.
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. All right, good luck, sir.
Is Graham coming? Graham's here? Okay. Your Honor, Graham, the next person I did not have a chance to talk to. I called out for him, but he did not come up, so I just wanted you to know.
Okay. Thank you.
You're welcome.
It's kind of a slow morning. For what?
Lunch, eat a lunch.
Oh. We could have waited. That's why we sent the email asking. Uh-huh. Please tell me your name.
David Graham.
You're here in 21MO851, charged with violating state misdemeanors. There is probable cause in this case. Do you want to have a moment to speak with an attorney? I think the state made an offer for your consideration.
Yes, Your Honor, he would like to resolve the case today. The state's offering a withhold of adjudication, credit time served. We briefly went over all the rights he would be giving up. He understands those rights and would like to accept the state's offer.
All right, sir, can you read English?
Yes, ma'am.
All right, there's a form right in front of you that explains the rights you're giving up if you enter a plea today. I'd like you to read that form and let me know when you're done.
Okay, ma'am.
All right, let me have you raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
All right, sir. You had a chance to speak with an attorney and also review the rights that you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights? Do you have any questions for me about them? Do you understand that if you enter a plea of guilty or no contest, that could violate probation if you're on it anywhere?
Yes, ma'am.
If you're not a U.S. citizen, you can be deported. All right. At this time, sir, how do you wish to plead to violating state misdemeanors?
Guilty.
Did you say guilty? All right, I'll withhold, I accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in custody. I have to order that you pay court costs. I'll give you a year to pay them. And order that you, nope, that's it. All right, good luck, sir. You have 30 days to appeal in writing. Please tell me your name. 21MO852, you're here charged with open container of an alcoholic beverage and violating state misdemeanors. There is probable cause. Was there an offer?
Yes, Your Honor, a withhold of adjudication, credit time served. I did speak to Mr. Nahart. We went over all the rights he would be giving up. He would like to accept the state's offer here today, and he understands all of those rights.
Please raise your right hands. Right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am. Yes, ma'am.
All right, you had a chance to speak with an attorney and review the rights that you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No.
You understand if you're on probation anywhere, this plea can violate that.
Yes, ma'am.
And if you're not a U.S. citizen, you can be deported.
Yes, ma'am.
At this time, how do you wish to plead to the charges of open container of an alcoholic beverage and violating state misdemeanors?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in custody. I have to order that you pay court costs, and I'll give you a year to pay them. Good luck, sir. You have 30 days to appeal in writing. Please tell me your name.
Jeffrey Smith.
21MO853, you're here charged with possession and consumption of alcohol in a place where prohibited. There is probable cause. Was there an offer?
Yes, Your Honor, withhold of adjudication, credit time served. I did have a chance to speak to Mr. Smith. We went over all the rights he would be giving up. He understands those rights and would like to accept the state's offer here today.
Please raise your right hand.
Do you swear to tell the
Raise your
truth,
right
whole truth? Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, yes, ma'am.
All right, you can put your hand down. You had a chance to speak with an attorney and review that form that explains the rights you're giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes.
Do you have any questions for me about them? You understand? I'm sorry?
I don't want to waste the county's time getting like a public defender or nothing like that. Something, and just plea out.
Well, that's who you spoke with. You spoke with an attorney.
Okay.
That's who explained the rights to you. But if you want to enter a plea, you can enter 3 pleas today. Not guilty. Will not resolve your case today. I'll give you bond and you'll be set for another court date. Or if you enter a plea of guilty or no contest, I'll sentence you today. What do you want to do?
I plead guilty. Guilty.
All right, so you understand the rights you're giving up by entering that plea?
Yes.
Do you have any questions for me about them?
No, ma'am.
You understand if you're on probation anywhere, this could violate that?
Yes, I'm not on probation.
And if you're not a U.S. citizen, you could be deported?
Yes.
All right. And I'm sorry, did you say you wanted to plead guilty or no contest?
Guilty.
All right. I accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in custody. Sir, I have to order that you pay court costs, and I'll give you a year to pay them. All right. Good luck, sir. You have 30 days to appeal in writing.
Thank you.
Yes, sir. Sir, please tell me your name.
Gregory Sproul.
21 MO 854. You're here charged with open container of an alcoholic beverage. There is probable cause. Was there an offer?
Yes, Your Honor, it was a withhold of adjudication credit time served. Could I have a moment? This was another one I called out for.
Yes.
Your Honor, I briefly went over all the rights he would be given up. He understands those rights and would like to accept the state's offer here today.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right, sir, you understand all the rights you're giving up. You can put your hand down. If you enter a plea of guilty or no contest,
Yes, ma'am.
do you have any questions for me about them?
No, ma'am.
You understand if you're on probation anywhere, this plea could violate that.
Yes, ma'am.
You understand if you're not a U.S. citizen, you could be deported.
Yes, ma'am.
All right, sir, at this time, how do you wish to plead to open container of an alcoholic beverage?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in custody. I have to order that you pay court costs, and I'll give you a year to pay them. Good luck, sir. You have 30 days to appeal in writing. Yes. Yes. Yes, I had to think for a minute. Please tell me your name.
Keith Berry Worrell.
21 MO 855. You're here charged with open possession and consumption of alcohol where prohibited. There is probable cause. Was there an offer?
A withhold of adjudication credit time served. I did speak to you, right? Okay. Your Honor, we did go over all the rights Mr. Worrell will be given up. He understands those rights and would like to accept the state's offer here today.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
All right, sir. You had a chance to speak with an attorney and go over all the rights that you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes.
Do you have any questions for me about them?
No, ma'am.
You understand if you're on probation anywhere, this plea could violate that?
I'm not on probation.
I believe you, but I have to ask everyone.
Okay.
You understand if you're not a U.S. citizen, you can be deported?
Okay. I'm U.S.
All right. Again, I have to ask everyone, just to make sure they understand. All right. At this time, sir, how do you wish to plead to the charge of possession and consumption of an alcoholic beverage where prohibited?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in custody. I have to order that you pay court costs. I'll give you a year to pay it. Good luck, sir. You have 30 days to appeal in writing. Please tell me your name.
Samuel Leon McCall.
20 CT 759. You're here charged with driving while license suspended with knowledge. There is probable cause. I'll appoint an attorney to represent you.
An offer was conveyed, Your Honor, of an adjudication credit time served.
Can I have just a moment? Your Honor, the state did make an offer. However, my client just has, he states around $300 to pay to get his driver's license. So I would just ask that he qualifies for pretrial release, if he can be placed on pretrial release, so he can have a chance to get his driver's license.
What says the state?
There is no objection.
All right, I'll place you on pretrial release. Sir, you understand you can't drive without a valid Florida license?
Yes, ma'am.
Good luck.
What happened to Mr. DeSir?
He bonded.
Thank you.
Bonded. Please tell me your name.
Michael McDonald.
A capias was issued for your arrest in 20 CT 419 for maybe failing to appear for a status hearing on a charge of driving while license revoked with knowledge. The bond on that is $1,500. I'll appoint an attorney to represent you.
And Your Honor, there was an offer of an adjudication of guilt credit time served. I did speak to Mr. McDonald. However, there is a hold, so I just wanted to let him know he will not be getting out.
Their FDLE holds?
What's the hold?
It looks like for Charlotte County.
He's also out on bond on 2 felonies.
Correct. The issue was that they were giving him time to get his driver's license. I'm not sure if he's going to be able to do that now, so I just wanted to let him know.
Okay.
Okay, Your Honor. He would like to resolve it today. I did have a chance to speak with him earlier. We went over all the rights he would be giving up. He understands that, I don't know how many driver while license suspended charges he has, but I did inform him that his driver's license could be suspended and he could potentially be charged for a felony in the future, depending on how many he has. And he would like to accept the state's offer here today. So you can always wait.
He failed to appear for court on the first day of June 2021.
Until you resolve these.
What was the state's offer?
An adjudication, Your Honor. The Charlotte case that he is being held for is also a dwellis with 4 other felonies.
And so I believe the issue is that he's not getting out. It says 0 bond, I believe, the hold. He doesn't have a bond on that one. And he's not going to be able to deal with that case until he resolves his Orange County cases. So I do not believe he'll have a chance to get out to get his driver's license, Your Honor.
You just made.
Also, I have an active warrant from Palm Beach County.
I see that as well.
And Ms. George, just so you know, he is adjudicated guilty on a 2020 Orange dwellis. He has another open 2020 Orange dwellis, another open, and then this 2020 Orange dwellis.
So, Your
And
Honor.
then one from Charlotte that's currently pending as well.
Okay. So, Your Honor, I would just ask that at this time you stay the bond in that case. And let me just. Okay, Your Honor,
I'll do that. I'm going to take no action on the out on bond cases, but
Thank you.
I think you want to talk to your attorney because you have lots of them pending and you might want to, you need to make sure that you have a chance to understand all of the consequences before you enter a plea on that. Good luck, sir.
Summit, bonded.
Please tell me your name.
Christopher Blake now.
All right. I have 21 CF 8819, 8818, and 8820. I have 3 cases where he's charged with petty theft with 2 prior convictions.
Yes, Your Honor. They're all separate incidences. They connected them, I believe, being like seeing the clothing.
I'm sorry, say that one more time?
They're all separate incidences. The first one, June 13th, 1821 at the Circle K. That is the 8819. At the 8820, it was 61, and it was at a Circle K, a different Circle K. And then the 8818 is 66 at a BP. So they're all different. They were all connected due to a photo lineup of multiple thefts.
All right, now I understand. I was missing the dates.
Yes, Your Honor.
And so I thought something was missing from what I was reading, but
No, Your Honor.
thank you. Now that I understand the dates, there is probable cause here. I'll appoint an attorney to represent you in each of these cases. Your bond will be $1,000 in each case. You're not allowed to return to these stores or have contact with any victim or witness in the case. Do you understand that?
No.
Good luck. Thank you, Ms. May.
Yes, Your Honor.
Please tell me your name.
Juan Crispin.
A capias was issued for your arrest in 19 CF 7609 for failing to appear for a case management conference on charges of possession of controlled substance. There's no bond authorized on this capias, and I'll appoint an attorney to represent you. Good luck.
All right.
Please tell me your name.
Jamal's David.
A capias was issued for your arrest in 20 CF 14537 for failing to appear for arraignment on a charge of burglary of a structure. The bond authorized on that capias is $5,000. I'll appoint an attorney to represent you. Good luck, sir.
Thank you.
Please tell me your name.
Peter Davis.
A capias was issued for your arrest in 18 CF 8932 for failing to appear for status hearing on charges of burglary of a structure, robbery, criminal mischief, battery, and resisting without violence. There is no bond authorized on that capias, and I'll appoint an attorney to represent you.
When these charges come from 2019?
The case is from 2018, the case number.
Ma'am, I got ruled incompetent twice to stand trial in this charge. And I was in the hospital, and I just got out of Osceola County Jail for 7 months. And I didn't have no idea I had to go to court.
I believe you, but I can't change it because it's a capias and I can't by law change another judge's capias. So if you think you have some defenses like you were in the hospital, you got to talk to your attorney because they have to bring it in front of the judge who issued the capias. I can't change it.
So a case I already done got sentenced on, ruled on, y'all mean to tell me 2 years later y'all can issue a warrant for somebody to arrest? That's crazy, man.
It's a capias.
I don't understand that, man.
All right.
Seriously, man. Y'all railroad people. Bullshit, man.
All right, so we weren't done with his cases. However, Ms. George, based on that behavior,
I'll waive his appearance, Your Honor.
21 CF 8850, there is probable cause. I'll stay the bond at $1,000. No contact with any known drug dealers. No controlled substances without a valid prescription. What about these out on bond cases?
He has, I think that was the issue. He has been deemed incompetent, Your Honor, but the case is still open, so I don't know. In these cases,
What says the state?
In the Osceola cases, Your Honor?
Yeah.
Given that he's being held no bond, I'll leave it within your discretion, Your Honor.
I'm going to take no action. Please tell me your name.
What's your name?
Lakeisha Fincher.
A warrant was issued for your arrest in 21 CF 8768 for fleeing or attempting to elude law enforcement and resisting without violence. Another judge has already found probable cause. I'll appoint an attorney to represent you.
and Your Honor, I would just ask that you consider the fact that she has no criminal history. She does
see that.
apply for pretrial release. If you're not inclined to place her on straight pretrial release, I would just ask for a pretrial release and a monetary bond, a small monetary bond in this case.
What says the state?
Your Honor, state would ask for PTR with bond, given the danger to the officers. I believe one was at the driver's side door, one was at the passenger side door when she sped off. So state would ask for PTR with bond.
I'll place you on pretrial release, but I'm also going to require that you post a monetary bond. It'll be $5,000 on count 1 and $100 on count 2. You're not allowed to possess or consume any controlled substance without a valid prescription, and you'll be subject to random drug screens while you're on pretrial release. Do you understand?
No.
Do you understand what I just said?
I wasn't charged for a drug charge.
Do you understand what I just said?
I understand, but
Okay. I'm also going to order that you're not allowed to have contact with a witness in this case.
okay.
Please tell me your name.
John Gunwardino.
A capias was issued for your arrest in 17 CF 6584 for failing to appear for pretrial conference on charges of shooting at, within, or into an occupied vehicle and criminal mischief. There is no bond, and I'll appoint an attorney to represent you. Oh, he has an attorney?
I have a private.
Who? All right. He has an attorney, so I'm not going to appoint the public defender. Good luck, sir. Please tell me your name.
William Gross.
20 CF 10015, a capias was issued for your arrest for failing to appear for a status hearing on charge of petty theft with 2 prior convictions. There's no bond authorized, and I'll appoint an attorney to represent you. Good luck, sir. Please tell me your name.
Giovanni Gutierrez.
In 21 CT 1345, you're here charged with driving while license suspended. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can't drive without a valid Florida license. Do you understand?
Yes, ma'am.
In 21 CF 8849, you're charged with possession of oxycodone. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can't have contact with any known drug dealers or possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
All right, good luck. Please tell me your name.
L'Aquarius Jackson.
21 CF 8842. You're here charged with possession of cannabis with intent to sell or deliver and possession of cannabis greater than 20 grams. I'm going to appoint an attorney to represent you. Did you wish to be heard, Ms. George?
If it's to the intent to sell, there was a scale, there was 30.6 grams and 50 grams and plastic bags and cash.
I think there's probable cause, but,
I didn't mark it, that's what.
okay, I wanted to give you the opportunity, but I reviewed it and I find there's probable cause.
And there was a scale, Your Honor, so that's.
Right. There's definitely indicia. All right, sir.
Your Honor, I would just ask that you consider pretrial release. He has 0 failures to appear. It appears his last conviction was in 2017. So I would just ask for pretrial release, and if not, pretrial release and lower the bond amount that you give in this case, Your Honor.
What says the state?
Your Honor, state would ask for bond and PTR, given the amount of drugs he had, the intent element, and given he has some violent history.
I'm going to place you on pretrial release and require that you post a monetary bond. It'll be $1,000 on count 1 and $100 on count 2. You're not allowed to possess or consume any controlled substance while you're on pretrial release without a valid prescription. You'll be subject to random drug screens. You can't have contact with any known drug dealers. You can't have contact with the witness in this case. Any other conditions the state would request?
No, Your Honor.
Good luck, sir. About what?
I didn't hear what you said for the last sentence.
You can't have contact with the witness or co-defendant in the case.
Mr. King.
Mr. King, yeah. Good luck. Please tell me your name.
Bridget Kiner.
21 CF 8837, you're here charged with aggravated assault with a firearm and improper exhibition of a weapon or firearm. There is probable cause. I'll appoint an attorney to represent you.
Your Honor, I understand in this case that it is a relatively violent offense. I just ask that you take into account the limited criminal history and the fact that she has 0 failures to appear. So I would just ask for pretrial release in order to lower the bond amount that you would give in this case.
What says the state?
Your Honor, given that her last conviction was in 2011, state has no objection to her being put on PTR, but would ask for bond and conjunction due to the weapon and due to the multiple cooperating witnesses.
All right, ma'am, I'm going to place you on pretrial release
Yes, ma'am.
and require that you post a monetary bond, but I'll reduce that. It'll be $1,000 on count 1, $100 on count 2. You're not allowed to have contact with any victim or witness in this case. Do you understand what no contact means?
I have a question, though. My wife is a witness in this case, and we live together.
I need you to answer my question. Do you understand what no contact means?
Yes?
All right, hold on, let me look at this.
Her daughter and 3-week-old,
Yeah.
her wife and 3-week-old were present.
I'll allow you to have contact with her, but no other victims or witness in the case.
Absolutely.
You understand?
Yes, ma'am.
All right, you can't return to this Publix at 4042 South Cimarron Boulevard. You can't possess a weapon of any kind, firearm or ammunition. Do you understand?
Yes, ma'am.
All right, good luck.
Thank you.
Brandon Knox, you refuse court.
21 CF 8847. Miss George, I'm going to appoint your office. I find his refusal a willing waiver of his appearance today. There is probable cause in this case. His bond is $10,000 on count 1, $10,000 on count 2, $500 on count 3, $10,000 on count 4, and $10,000 on count 5. He can't possess a weapon, firearm, or ammunition. And at this time, I'm revoking his bond in 21 CF 7114. Please tell me your name.
Bruce E. Madison.
A warrant was issued for your arrest in 21 CF 8614, charging you with burglary of an occupied dwelling with a battery. Another judge has already found probable cause. Does the state wish to be heard?
Yes, Your Honor, given that it is a PBL, state's asking that you hold him no bond pending an Arthur hearing.
I will do that at this time, sir. You'll have no bond on that charge. However, even while in custody, you can't have any contact with the victim. Do you understand what no contact means?
Yes, ma'am, but I mean, I got 3 years DOC, so.
I'm sorry, what?
I got 3 years DOC, so the bond ain't.
Not on this.
No, he said the bond, it doesn't matter because he has 3 years DLC.
Okay. All right, good luck, sir.
Thank
you. Yes. Please tell me your name.
Ivan Nogueira Rivera.
21 CF 8835. You're here charged with possession of cocaine, fentanyl, less than 20 grams of cannabis, and drug paraphernalia. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000 on count 1.
I'm sorry.
Sorry.
I would just ask that you consider pretrial release. It appears he's on Social Security disability. His last failure to appear was in 2013. These are all nonviolent offenses, and it appears his criminal history is relatively nonviolent. I don't see anything.
What says the state?
Your Honor, I believe he potentially is out on bond in a different county. Will you give me 1 second, please?
Okay.
To the fact that also Ramirez stated that he has mental health issues, which is probably where the Social Security disability is coming
Your Honor, state has no objection.
All right, at this time, I'm going to place you on pretrial release with special conditions. You can't possess or consume any controlled substance without a valid prescription. You'll be subject to random drug screens while you're on pretrial release. You can't have contact with any known drug dealers. Do you understand? And you can't have contact with the co-defendant in this case. Good luck. Please tell me your name.
Mr. Norris?
A capias was issued for your arrest in 20 CF 15177 for failing to appear for a status hearing on a charge of aggravated battery causing great bodily harm. There's no bond authorized, and I'll appoint an attorney to represent you. In 21 CF 8832, you're charged with possession of fentanyl, possession of cocaine, and possession of drug paraphernalia.
No, that was not
Don't talk about the facts.
Gentlemen, that was not mine.
I believe you, but there is probable cause that you did possess those substances. Possession can be joint. It doesn't have to be just one person. So if you think you have some defenses, you need to talk to your attorney, who I'm appointing at this time. Your bond is $1,000 on count 1, $150 on count 2, $100 on count 3. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. You also cannot have contact in this case with the co-defendant. Do you understand? Good luck. So what does that mean? All right, we'll reset him for tomorrow.
You just unbonded, Your Honor.
Please tell me your name.
Samuel Pierre Lewis.
21MO856, you're here charged with open container of an alcoholic beverage. There is probable cause. I'll appoint an attorney to represent you. Your bond is $250. In 21 CF 8851, you're charged with possession of MDMA. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. At this time, I'm revoking your bonds in 21 CT 4838, 20 CF 14389, 21 MM 4701, 21 CF 8318, and 21 CF 8404. Good luck, sir. Yeah, they're on no bond. Please tell me your name.
Darvis Pruitt.
21 CF 8836, you're here charged with criminal mischief. There is probable cause in this case. I'll appoint an attorney to represent you. Your bond is $1,000. You can't have contact with any victim or witness in this case. You can't return to the scene for any reason.
Yes, ma'am. I would like to represent myself, though. I changed my mind after thinking about a whole lot of things. I just like to represent myself. And
Hold on, before you say anything else,
Okay.
let me explain what we're doing here today.
Yes, ma'am.
I reviewed the probable cause affidavit. I'm telling you there's probable cause, but we're not having an evidentiary hearing.
Okay.
So this is about probable cause and bond.
Yes, ma'am.
I understand you just told me that you want to represent yourself.
Yes, ma'am.
I need to ask you a few questions. What's the highest grade that you completed in school?
High school.
All right. You understand that the state is being represented by an attorney who's been to law school and practiced law.
Yes.
So you don't think you're at a disadvantage representing yourself?
No, ma'am, I don't.
Did you go to law school?
No, I didn't go to law school, but I have common sense.
All right. Have you ever been diagnosed with any mental health conditions?
Yes. No,
When?
No mental health, I'm sorry. I can't breathe in this mask today.
Yeah, I understand. I have asthma, it's hard.
It's not
So
asthma.
initially, when you said yes, what did you think I'd asked you?
Had I ever been to like a mental health facility?
Oh, okay.
Training?
So have you been to a facility?
Yes, I have.
When?
Back in November and a few years back, I went for being bipolar and depressed.
All right. So have you been diagnosed as bipolar?
Yes, I guess so. I don't take medication for it.
All right. Do you think that you're having are you feeling any effects from the bipolar disorder today?
No, ma'am.
Are you under the influence of any drugs or alcohol?
No, ma'am.
Did a physician prescribe drugs for you based on the bipolar diagnosis?
No.
So a doctor never told you to take any medication?
Not for bipolar. They gave me something for depression.
All right, but you don't take that?
No, I don't have a prescription for that currently.
But you don't feel depressed today?
No.
All right.
Can I ask you a question?
Hold on. You can say anything you want. I need to make sure you understand that everything you say is being recorded and can be used against you later. Do you understand that?
Yes, ma'am, I understand.
All right, go ahead, sir.
Yesterday when I got here and got booked in, I was told I was not going to have a bond at all. I have a badge on that I was supposed to be released yesterday afternoon, and then today I'm coming here and I'm getting a bond. What changed?
So I haven't addressed your out on bond case. That's probably why you were told that.
Oh, okay.
So on the criminal mischief charge, your bond is $1,000. However, I show that you're out on bond in
I don't bond for what?
21 MM 128. I don't know why that's an MM. It says burglary of an occupied dwelling. Can the state look that case up? Hold on, let me ask the state.
I was released from your jail. I wasn't on bond. I served 40 days.
Thank you for the promotion, but it's not my jail. Hold on, let me ask the state if they can look that up for me. I can't.
It came in as a burglary occupied dwelling in F2. We ended up filing a trespass other than structure and conveyance and criminal mischief. We filed that.
Was it at the same place?
January 5th, 2021. The location of that was a sober house located
Torres Drive.
I'm sorry?
It was 5039 Oak Torres Drive is where that crime happened.
Yes, Your Honor.
And I served 40, 60 days here in jail. I'm not sure how long, but I was here a minute for the first time ever in Orange County. And you released me on my own recognition. I didn't know I was on bond.
When I say bond, being released on your own recognizance, it's the same thing. You've been released. So what happens is if you're out on bond or ROR and you are arrested for committing a new crime, at that time, I can revoke that bond and hold you at no bond. So I think that's what you were told yesterday.
No, I wasn't told that yesterday. I wasn't even told about that charge yesterday.
I thought you said someone told you you had no bond.
They told me that I was going to be released at a certain time yesterday. They ran my name for certain cases in different states. They ran my name for charges elsewhere, like for hours. And I was told I was going to be released by 8 o'clock. And I was not released by 8 o'clock. So I knew something was with the games. But
Your Honor, I believe on the out on bond case, it was set for a plea. I believe that the client was, as he stated, in rehab. So it looks like they were trying to do the plea, because it was a credit time served plea, in his absence, and I think that's where the confusion is. It's still set for the police notice of hearing, I guess,
The plea is August 13th.
yeah, for him to plea to, it says an adjudication, court cost and no return.
What says the state as to the out on bond case?
Your Honor, given that they're close in nature, given the offense that was actually charged, they would ask that you revoke and at least double.
You don't represent him. I haven't appointed you.
On the out on bond,
Oh, you do on the out on bond?
we do. Your Honor, I would just ask that you consider the fact that he was in fact in rehab. He's also security income. I believe in this case, they're set to resolve it. They originally tried to send the plea offer to him in rehab. That didn't work out, so they're going to resolve the case with credit time served. I would just ask that you not make him pay an additional bond on a case that he's going to resolve next month.
What concerns the court is that while out on bond for committing a crime, he committed this new offense. And based on the probable cause affidavit, I'm very concerned about the behavior.
Ma'am, that's,
Hold on one second. So one of the things that what I have to balance is the defendant's right to be released with protecting the public and also the victim in the case.
public isn't in danger here, ma'am. This was an ongoing dispute with a person who's been infiltrating my life for the last forever long, 5 years, 6 years. I'm not that kind of criminal. I don't go around and destroy people's stuff or breaking people's houses. That's not what I do.
Well, I believe
Appreciate that.
The synopsis of the out on bond, it was a sober house, occupants heard noises. There was a point of entry through the kitchen window, large shards of glass were found in the sink. None of the occupants knew the defendant. He tried to use a door code which did not work, and he entered through the kitchen window. The house owner and manager confirmed that he did not have any resident by his name. So not one of the criminal mischief being breaking glass into a home. In this case, it's breaking glass into a vehicle.
I didn't break into her vehicle. I broke her windows. And that home was
Your Honor,
that home was a transitional house. I left for rehab and went to that house. So if I had no business at that house or in Florida, I wouldn't be at that house.
And again, Your Honor, I would
All right.
point to the fact that they charged it as a trespass.
They did. All right, here's what I'm going to do at this time, sir. Mr. Pruitt, I am going to revoke your bond in that case. I want to make sure that you understand that now you're going to be held at no bond. Do you still
I was
not
gonna
want
be
me
held at no
to,
bond anyways, ma'am. Go ahead.
but do you still not want me to appoint an attorney in your new case?
No, I'm good. You're gonna do what you're gonna do, and my point is still gonna be made. Thank you.
We're appointed to the out on bond case, Your Honor, so that.
Okay, all right. Good luck, sir.
Thank you.
No. But
Oh, I understand.
can you guys approach? All right, I'm going to go back to that case. I don't think he's competent to represent himself, so at this time, I'm going to appoint the public defender's office. Obviously, when he gets downtown in front of the trial judge, they can change that. Please tell me your name.
Carlos Rivera.
A warrant was issued for your arrest in 21 CF 8300, charging you with armed burglary, criminal mischief, and grand theft. There is probable cause. I'll appoint an attorney to represent you. Does the state wish to be heard on bond on count one?
Your Honor, I'm sorry, what defendant is this?
Rivera?
Oh, the other case. In regards to count one, which is a PBL, state is asking that you hold him no bond pending an Arthur hearing.
At this time, you'll have no bond on count one. I'll stay the bonds at 150 on 2 and 3. You can't have any victim contact. You can't have any co-defendant contact. You can't possess a weapon, firearm, or ammunition. You can't return to this scene for any reason. In 21 CF 8844, you're here charged with possession of heroin within 1,000 feet of a place of worship with intent to sell, and possession of heroin with intent to sell or deliver. I'm going to appoint an attorney to represent you.
Your Honor, I would argue as to the intent to sell. Here, if you read the arrest affidavit, it states that he had a bloody arm, he had syringes. I do not believe he had any sort of a scale or anything to that effect that will point to intent to sell a large amount of money. So I would just argue there's no PC for possession of heroin with intent to sell.
Your Honor,
Says the state.
The argument that it was a large amount of heroin, 3.5 grams is large on the streetwise of total weight for heroin. It's usually sold in like 0.1, 0.2. So 3.5 grams is fairly large. And in addition, they found a clear plastic bag containing multiple smaller dime-sized bags that were recovered, which are usually pieced together to be able to sell. So given the large amount of heroin and the smaller dime-sized bags, so we contend that there is indicia of sale, and would ask that you find PC.
Your Honor, the court has recognized that having small bags and in your possession is not enough to charge someone with intent to sell.
Is it small bags that are filled with drugs or some small bags that are empty?
You have a case?
It was actually, I'll pull it up. It was actually small bags with drugs in it, the case that I read, Your Honor, and I'm gonna see if I can.
Because that's different than this case. In this case, he had a bag with multiple baggies in it, and then a large amount of drugs.
Yes, Your
So it seems as though it indicates that the plan is put the drugs in the small bags.
Your Honor,
But if there's a case that says not,
No, most of the cases that I've read, they've already had drugs in the individual baggies, Your Honor.
Your Honor, my understanding, and with what you just articulated for the court, when there's just drugs and other small baggies, it's not necessarily indicia. My argument being, he could have just bought them, and that's why they're in small baggies. When there's a baggie full of baggies and a large amount, I feel like it points more towards likely taking that large amount and breaking it up for other sale.
Correct, Your Honor. The case law that I've seen, their drugs are already in the small baggies.
because I'm not asking him to say anything, but it just seems to me like the question would be, if it is for personal use, which there's indicia of personal use as well, but why would you have that many small baggies? If you're just going to keep it yourself, you just have your big amount in one bag. You don't need to divide it up.
Correct, Your Honor.
Right?
Yes, Your Honor.
I appreciate your argument. It's close to the line.
Yes, Your Honor.
But however thin, I do think there's probable cause here. Whether the state can sustain a conviction is a completely different question. But I'm going to reduce the bond. So your bond will be $10,000 on count one and $1,000 on count two. You can't return to this scene for any reason. You can't possess any weapons, firearms, or ammunition. You can't have contact with any known drug dealers, and you can't possess or consume any controlled substance without a valid prescription. Do you understand? Did you hear what I said? Yes, do you have a question?
The first one is no bond.
Right. It's a life felony. It's a felony punishable by life in prison.
The gun. It's plastic gun. It don't, no, it's real
Right.
gun.
Don't talk about the facts.
Right, so what's going to happen is your attorney will file a motion to be heard in front of the trial judge. It's not no bond forever, it's no bond today. They'll file a bond motion and call witnesses, but at this time, it's no bond. So call the number on that piece of paper. Do you understand?
Right.
Good luck, sir. Please tell me your name.
Jose Rivera.
21 CF 8821, you're here charged with possession of methamphetamine and paraphernalia. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000 on count 1, $100 on count 2. You can't have contact with any known drug dealers or possess or consume any controlled substance without a valid prescription. Good luck. Please tell me your name.
Ron Schroeder.
A capias was issued for your arrest in 21 CF 1522 for failing to appear for a status hearing on charges of fleeing or attempting to elude law enforcement and resisting without violence. There's no bond authorized on the capias. I'll appoint an attorney to represent you. Good luck, sir. I'm sorry?
Is there a chance that I get one on the 29th?
Get one what?
Bond.
In front of the trial judge. I can't change another judge's capias, so you have to ask that judge for a bond. Good luck. Please tell me your name. 21 CF 8810, you're here charged with possession of burglary tools, grand theft, possession of drug paraphernalia, resisting without violence, and criminal mischief. There is probable cause. I'll appoint an attorney to represent you. Your bond is $150 on count 1, $1,000 on count 2, $100 on 3, 4, and 5. You can't return to the scene for any reason. You can't have contact with any victim or witness. You can't possess a weapon, firearm, or ammunition. At this time, I'm revoking your bond in 20 CF 178. He has your office in that case as well.
Yes, Your Honor.
All right, good luck, sir. Please tell me your name.
El Solis.
A warrant was issued for your arrest in 21 CF 8816, charging you with sexual battery on a person physically incapacitated. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you.
What do you mean, another judge?
So a warrant was issued, so a judge reviewed that warrant and signed it. That's the judge that has already found probable cause.
Okay, so, there's no bond?
There is no bond on the warrant.
Your Honor, he is entitled to bond under 794.011 sub 4. So he is entitled to bond. State would just ask for a high bond given the facts in this case and the corroborating DNA evidence.
And Your Honor, I would just ask that you take into consideration his, he has no criminal convictions or history that I'm seeing.
I show,
Sorry, wrong person. There was a.
Yeah, I was gonna say.
You have two, sorry.
Okay.
Wrong person.
Your Honor,
I see a felony, a misdemeanor. Hold on, let me explain. Everything you say is being recorded and can be used against you later. Do you understand that?
I understand.
Okay, is there something that you want to say?
Yes, I'm a father. I'm a great father. I have kids. I'm not guilty. I'm the one that helps the mother with the kids. You know, she works, so I'm a stay-home dad with the kids, you know. I have 3 daughters. You know, I'm no harm to anybody. Wasn't harm in the situation. You know.
Does the state wish to be heard on bond?
Your Honor, he has a fairly lengthy history. And just given, as I said before, given the nature of the offense, the corroborating DNA evidence, and the incapacitated nature of the victim, I believe both victims, state would just ask for a high bond. He has a pretty good history.
I see two convictions in its history?
He has a resisting, a dwellis, possession of cannabis, grand theft, third degree, violation of probation, petty theft, no valid, dwellis, providing false ID to law enforcement.
Convicted of?
Wait, are those convictions?
Yeah, because I'm not showing that.
I show resisting without violence 2 months ago.
2021
theft.
Resisting. A
And another
dwellis.
resisting without.
I have he pled no contest to a resisting 2021.
Yeah, I
He
see
has a
that.
2019 pled no contest to a dwellis. He had a 2018 neglect of a child that was no billed. He had a 17 possession of cannabis that he pled no contest to. He had a 2017 felony burg dwelling grand theft that was null prost. He had a 2015 grand theft that he pled no contest to, as well as a VOP. He had a 2014 misdemeanor petty theft that he pled no contest to, and a 2013 no valid that he pled no contest to.
And 3 prior failures to appear.
Yes, Your Honor.
Your bond is $25,000. You can't have any contact with any victim or witness in this case. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You can't possess or consume any alcoholic beverages or any controlled substances without a valid prescription. You can't return to the Days Inn at 3300 South Orange Blossom Trail for any reason. Do you understand? Good luck. Yes, sir. Please tell me your name.
Victor Torres Morales.
21 CF 8822. You're here charged with attempted burglary of an occupied dwelling and trespass in an occupied structure. I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond is $5,000 on count 1, $100 on count 2. You can't have contact with any victim or witness in this case, and you can't return to
3332 South Cimarron Boulevard,
That's it.
11.
Do you live there?
No, my friend lives there.
Okay, don't go back and see your friend. Tell your friend he has got to come to your house, okay?
Okay, thank you.
All right, good luck. Please tell me your name.
James Turner.
In 21 CT 5314, you're here charged with no valid driver's license. There's probable cause, and I'll appoint an attorney to represent you. Your bond on that is $250. In 21 CF 8831, you're charged with fleeing or attempting to elude law enforcement with lights and sirens activated. There is probable cause for that charge as well. I'll appoint an attorney to represent you. Your bond is $15,000. Sir, you understand you can't drive without a valid Florida license? Good luck. Please tell me your name. 21 CT 5315 and 5316. You're charged with driving while license suspended and no tag or registration. There is probable cause. I'll appoint an attorney to represent you. Your bond on each of those cases will be $500. In 21 CF 8845, you're charged with possession of amphetamines. There is also probable cause for that charge. I'll appoint an attorney to represent you. Your bond is $1,000. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand? All right, good luck, sir. Please tell me your name. 21 CF 8846. You're here charged with sexual battery. I'm going to appoint an attorney to represent you. There is probable cause in this case. Does the state wish to be heard on bond?
Your Honor, he's entitled to bond. I believe it's an F2, as it's not enhanced. The state would just ask for a bond that is in keeping with the facts in the case, as as well as taking into account his other arrest history. I'm going to
I don't, I see only one other arrest.
It was also for a lewd sexual offense, though, Your Honor.
It was.
Your Honor, and I just actually take into consideration he was not convicted of any crimes.
Can I speak?
You can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that?
I would recommend you not talk about the facts of the case.
I'm innocent of this. I don't.
I can't hear you.
Your Honor, he does have other arrest history. There was a the case that he was arrested for was July 20th.
Of this year?
Well, July of 2020.
Oh, okay.
And it was in regards to a sexual battery.
Did you have this to appear?
There was a decline to prosecute on that case. He also has arrest history of an aggravated battery from 2013, which was also a decline to prosecute.
Yeah, my client is disputing that he had any other arrest other than the.
The last time I was arrested was 2005. I don't have any other arrests. And I believe that was expunged. I attempted to.
At this time, your bond is $40,000. You're not allowed to have any contact with the victim. Do you understand what no contact means? Are you still employed?
I don't know after this.
What do you do at this dealership? What's your job?
I'm a technician. I'm 2 classes away from being a Nissan Master Tech, and I'm trying to climb the ladder and have the class next month. And this is all up to her. She filed.
Don't talk about the facts.
She filed.
What I'm trying to determine, I'm sorry, go ahead.
She filed a false police report.
What I'm trying to determine is it part of your job normally to meet with customers and go in car rides with them?
Yes, for test drives.
You can't do that now.
Yes, ma'am.
I don't know how to order that, but that can't be part of his job.
Definitely not do that anymore.
I would just object. I would argue that it's too broad. It's part of his job. I'm not sure that he.
I'm okay with that. That's totally the deal.
Have another tech take them on the car rides.
That's completely.
Yeah, I just didn't know if that was the only job. I don't know how that works.
A tech would be like, you work on the cars, right?
That's what I thought.
Right, I work on the car, but sometimes if there's a noise, it's hard to kind of, like someone says the transmission's whining, but it's a wheel bearing. So sometimes you have to hear what they're hearing to make sure you do the right repair. But if that's what I have to do, that's what I have to do.
So
Right,
he
if
can.
that's what I don't have to do anymore, I will not drive with best service anymore.
He can do that. You just can't do it with.
Right, so he can do the job. I'm not telling him he can't work. I'm just saying, don't do the test drive where you're alone in the vehicle. If there's another tech in the car with you, that's okay, but you can't be alone in the vehicle with a customer.
Understood.
Do you understand?
Yes, ma'am.
And really, that helps you too, at this point.
I agree.
Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir. Yes. Please tell me your name. All right, so someone from your office appeared on this case this morning? Ms. George, 2014 CT 11987.
I spoke with the person assigned, the PD assigned. He stated it was not him, so I'm just gonna enter a denial, Your Honor.
Do you have an attorney in this case? Do you have an attorney? No. No, you don't? Okay, so.
I will, sorry, not a denial, not guilty, I don't know why.
It's a denial because it's a VOP.
Okay.
For this is Castro Murillo.
Mm-hmm.
In our system, we have it as Richard Parker.
I have Angel Castro. Angel
Castro
Castro.
Murillo. I have his
Fernando.
defense attorney as Richard Parker.
I have Castro Angel.
I don't have a Murillo.
Yeah.
What's your whole name?
It's,
So
Your
you
Honor, it's
have,
his case number in our system.
all right.
Due to the
In
Hispanic
ours-
last names.
But it's showing the same thing in ours that we're represented, so I'm not sure.
You have who?
Case number do you have it
987.
14 CT 11987.
There's an NOA from 7/26 of 2021 for Mr. Parker.
I'm just telling you, he's in our system as we're appointed, the attorney. Let me see. I spoke with the attorney assigned to the case today.
All right, here's what we're going to do. She thinks she's appointed. They're going to enter a denial. We'll set it for the VOP date, and then the two attorneys can work it out.
Thank you.
She's going to give you the date. Just a minute.
VOP status will be September 13th, 9 a.m., courtroom 4E.
All right, good luck, sir. And Ms. George, can you just put a note in your file about that so the
Yes, that's
attorney knows that there might be a private attorney?
Richard Parker.
Okay, go ahead.
Who's next, Your Honor?
Gordon.
Gordon, TOT, With prison, you know.
I do not know what these letters mean.
Yeah, Department of Corrections.
I thought you said TOT.
Yeah, turned over to.
Yeah,
So he went to.
TOT turned over.
All right, 21MM91. Ms. George, your office represents him, but it sounds like he's been turned over to the Department of Corrections.
So I'll waive the appearance until not guilty.
Yeah, good idea.
Division 63 pretrial conference will be